defund the police, and then they want to take our Second Amendment right to defend ourselves.
Change a law. They are already used to breaking the law, and the people will still do it, will continue to do it.
Guns don't kill people. People kill people. Criminals, miscreants will always get their hands on guns.
Our Second Amendment. It's a hell no to government trampling on our freedoms.
If you were serious, you would acknowledge that 96% of mass public shootings happen in an area where guns are banned.
As of this morning, there have been 255 mass shooting incidents in America.
Firearms regulation in the United States. The authority to regulate firearms is shared by the federal, state, and local governments. State laws pertaining to gun ownership, registration, and carry have been passed by individual states. The manufacture, sale, and possession of firearms are governed by federal law in the U.S. States are allowed to add restrictions to this framework, which establishes a standard for the appropriate use and handling of firearms.
As of this morning, there have been 255 mass shooting incidents in America.
But, Madam Speaker, guns have been prevalent in the United States of America since before our founding.
I think you need to have weapons to take on the government. You need F-15s and maybe some nuclear weapons.
The two primary federal weapons laws in force at the moment are the National Weapons Act of 1934, or the NFA, and the Gun Control Act of 1968, or the GCA, both as amended. In an effort to curtail crimes related to organized crime, the NFA, the main federal statute governing the acquisition and ownership of firearms, specifically targeted the kinds of weapons that gang members commonly utilized. Congress approved the Gun Control Act in response to the killings of Dr. Martin Luther King Jr. and Senator Robert Kennedy. The Act's goals are to prevent prohibited individuals from possessing firearms and to support law enforcement in their efforts to reduce crime. In general, the GCA regulates the manufacture, transfer, and ownership of firearms, even those kinds of weapons that are not protected by the NFA. It specifies who is allowed to acquire, sell, and possess firearms, as well as how these transactions may be done legally.
If you were serious, you would acknowledge that 96% of mass public shootings happen in an area where guns are banned.
We have the third highest gun-related injuries in the country, 90% higher.
It also specifies the kinds of firearms that may be possessed legally and the areas where such possession may be forbidden. The GCA was modified by the Brady Handgun Crime Prevention Act to require background checks. Several constitutional considerations may be taken into account in legislative proposals to modify the current system of limiting the sale and possession of firearms. Congress has broad authority to regulate firearms under the Constitution, but any legislation pertaining to firearms must be based on one of those powers. Historically, Congress has created laws governing firearms by using its powers over trade, taxes, and spending. When using its enumerated powers, Congress must keep in mind other constitutional constraints. The Second Amendment case law of the Supreme Court, especially District of Columbia v. Heller, protects an individual's right to keep and bear arms for defense. Furthermore, Congress cannot deprive someone of any constitutionally protected interest, such as the Second Amendment's right to bear weapons or their property rights to firearms and related accessories, thanks to the Fifth Amendment's Due Process Clause. These constitutional considerations bear on the scope of the measures that the 115th and 116th Congresses investigated.
Guns don't kill people. People kill people. Criminals, miscreants will always get their hands on guns.
Our Second Amendment. It's a hell no to government trampling on our freedoms.
The Second Amendment, from the day it was passed, limited the type of people who could own a gun and what type of weapon you could own.
To alter the existing federal legislative framework of weapons regulation. The proliferation of untraceable 3D printed firearms, gaps in data collection for background checks on prospective gun buyers, restrictions on specific types of firearms and accessories, the ownership of firearms by individuals with mental illnesses, interstate reciprocity for lawful concealed carry of firearms, and laws permitting courts to order the temporary removal of firearms from an individual have all been the focus of legislation. Haynes brought up constitutional concerns, which were addressed in the revision of Title II of the Gun Control Act of 1968. First, the registration requirement for owners of unregistered firearms was eliminated, and the statute was amended to include a clause prohibiting the use of any information from an NFA application or registration as evidence against an individual in a criminal case involving a law violation that occurred prior to or concurrently with the filing of the application or registration. The 1968 amendments resolved the original NFA's constitutional defect, according to the Supreme Court's 1971 re-examination of the statute in the Freed case. The NFA definition of silencer was expanded by the Firearm Owners Protection Act in 1986 to include parts combinations for silencers as well as any part intended for use in the assembly or fabrication of a silencer. The Act changed the GCA to make it unlawful to transfer or possess machine firearms. Mash arms that were lawfully in possession prior to the Prohibition's implementation date of May 19, 1986, as well as those transferred to or possessed by government agencies, were all eligible for exemption. The Bureau of Alcohol, Tobacco, Firearms, and Explosives, or the ATF, released a final rule on January 31, 2023, renaming some weapons with braces as short-barreled rifles. Previously, these weapons were exclusively governed by the GCA and were classified as pistols. Reclassified as SBRs, they are now governed by the stricter 1934 National Firearms Act.
Getting assault weapons, AR-15s, out of the hands of people who shouldn't have.
Change a law. They are already used to breaking the law, and the people will still do it, will continue to do it.
Gun violence in this country is an epidemic, and it's an international embarrassment.
Until they are registered with the Attorney General under the NFA, nearly all rifled-bore firearms with less than 16-inch barrels that are braced or equipped with similar devices seem to be forbidden from being transferred under the law. There are several options available to private owners of these firearms and FFLs to comply with the law. They can file an NFA tax registration form with the ATF before May 31, 2023, free of charge. Alternatively, they might alter the guns by permanently removing the bracing or replacing the 16-inch barrel with a longer one. Some members of Congress have proposed legislation that would nullify the ATF regulation and remove all guns with short barrels and similar weapons from the NFA's regulations. To assist FFLs and other parties in meeting their legal requirements, the ATF allocates firearm categories through letter rulings, open letters, and other documented confidential conclusions. The ATF's Firearms and Ammunition Technology Division is the main government organization responsible for classifying firearms and ammunition in compliance with federal law. FATD also manages requests for evaluations of domestic manufacture and importation, as well as marking deviations. Firearm regulation landscape. Newly, the ATF expanded the definition of rifle to include rifled-bore weapons, equipped with a stabilizing brace or other such device that provides sufficient surface area for firing from the shoulder. Millions of people who have bought or made firearms with braces have been impacted by this shift, and detractors claim that the ATF has overreached itself by putting lawful gun owners in jeopardy of punishment while neglecting to address the root causes of armed crime. In support of their argument that the restriction is both within the bounds of the ATF's allowed authority and advantageous to public safety, supporters of the rule point to 4 significant public killings in which the perpetrators used braced weapons. Enforcing the NFA and the GCA falls under the purview of the Attorney General.
This rule turns law-abiding gun owners into felons is a result of unelected bureaucrats. Second Amendment protects firearms in common use at the time and also said this, quote, for lawful purposes like self-defense.
That you said that all assault weapons should be banned. Is that a fair statement?
Under the guidance of the Attorney General and Deputy Attorney General, the Director of ATF is in charge of implementing and upholding the GCA and NFA. The Director of the ATF assigns the Firearms and Ammunition Technology Division, Firearms Technology Criminal Branch, and Firearms Technology Industry Services Branch the power to categorize firearms in accordance with the GCA and NFA. The terms firearm are defined differently by statute in the GCA and NFA. Congress enacted the NFA in 1934 to regulate gangster-type firearms, which were considered particularly uncommon and dangerous. As a result, these weapons are subject to taxes and must be registered with the ATF. The designation of a weapon as a firearm under the GCA or the NFA changes how it is regulated under federal law, and the Supreme Court acknowledged these additional restrictions as consistent with the Second Amendment. To achieve appropriate classification, a careful investigation and consideration of the many configurations, materials, and designs of contemporary firearms are necessary. It's not a given that a handgun made with an accessory labeled as a stabilizing brace will still be considered a pistol.
I think you need to have weapons to take on the government. You need F-15s and maybe some nuclear weapons.
But at the crux of this is a bureaucrat making a unilateral decision to try to turn millions of Americans into felons.
Defund the police, and then they want to take our Second Amendment right to defend ourselves.
There is a risk that a firearm classification based on a single restricted feature, like the manufacturer's label, will be noticeably too inclusive or too restrictive. By specifying what constitutes a rifle and establishing whether a firearm is made with the intention of being fired from the shoulder, the proposed ATF Worksheet 4999 seeks to guarantee legal compliance with the GCA and NFA. Guns with a rifled barrel and an attached stabilizing brace that have objective design features and characteristics indicating that the weapon is intended to be fired from the shoulder will be subject to the new rule's application of stabilizing brace requirements. This new rule will assist industry participants in creating legally compliant products and lower the possibility of facing criminal or civil penalties or necessitating corrective measures such as manufacturer recalls. After just 1 month in the current Congress, Representative Eric Burleson has already made a significant influence on the contentious issue of repealing the National Firearms Act. With the goal of lowering the use and possession of automatic weapons and other guns by a mix of fees, registration regulations, and application procedures, the almost 89-year-old statute was the first piece of legislation approved by Congress. The bill was never put to a vote in the House, which was then controlled by Democrats, and Rep. Lauren Boebert was the lone Republican sponsor. There are now 9 Republicans who are co-sponsoring the current bill. There is a waiting vote in the House Ways and Means Committee. A federal trial court recently ruled that the ATS frames and receivers rule is wholly illegal in the case of that regulation. The Texas Federal District Court's Judge Reed O'Connor was correct to invalidate some parts of the ATS frame and receivers rule, and the Fifth Circuit granted the ATS's request for a stay, ruling that it was reasonable for him to do so. While this is great news for a significant win for the professional side, the ATF also saw some little wins from it. According to the Fifth Circuit's opinion, when the government wants an emergency stay, there are 4 important factors to consider before granting or refusing the ATF stay. The government's motion to suspend the regulation is denied because the ATF has not shown that it would win on the merits or cause irreversible harm in the absence of one. The extensive literature on the 2 challenged elements of the regulation indicates that removing it would return the situation to what it was prior to the rule's implementation. The express separability language in the ATS rule on frames and receivers has put the ATF in a difficult legal battle. The regulation, which has an unambiguous separability clause, was only one of 2 parts whose validity the district court looked at. The agency has proven that there is a good chance of success in proving that the scope of the rule's non-contested provisions was excessively broad. In order to provide time for further procedures as needed, the agency has expedited the appeal to the next oral argument schedule that is available. For 10 days, this order has been administratively stayed. The Fifth Circuit Court concurred with the lower court judge that the ATF exceeded its legislative power when it expanded the definition of a weapon to include an incomplete frame receiver. The ATF must make the difficult choice of appealing to the Supreme Court, asking for emergency relief, and asking the court to grant an emergency stay while the appeal is pending. Their plan would be to convince the Supreme Court that in order to secure their stay while the case proceeds through the Fifth Circuit appeals process, the court must intervene right away. This is hazardous, though, since their emergency motion could be flatly denied by the Supreme Court. In the event that the Supreme Court decides to reject the ATF, it may potentially examine the case and issue an order. In this case, the ATF would be in an even worse situation. Their best chance is that the Supreme Court will be forced to act and provide them with some sort of temporary relief by the ticking 10-day clock. It is important to remember, though, that Justice Alito hears emergency requests from the Fifth Circuit, and that means he would have jurisdiction over this case. Since the ATF does not favor Alito as a justice, this is not ideal for the government. Furthermore, in the absence of a full court referral, emergency decisions may depend exclusively on Alito's ruling, as the Supreme Court is not in session at this time.
Now, you could argue, actually, that the pistol brace makes the gun safer.
And said he supports a ban on the sale of assault weapons, which there's no such thing.
But I guess the other thing, the back door to, well, the assault weapons, absolutely, because there's no definitive.
If you did, you still couldn't use it because you couldn't go about your daily life without crossing through some type of sensitive location.
Let's see what is the most compelling thing to learn from that case. How many times was this gentleman...
So while everybody's distracted with New Mexico's ban on open and concealed carry, SB 2 was California's answer to the Bruin decision because just like New York...
Since the ATF does not favor Alito as a justice, this is not ideal for the government. Furthermore, in the absence of a full court referral, emergency decisions may depend exclusively on Alito's ruling, as the Supreme Court is not in session at this time. It will be interesting to observe what the government ultimately decides to do and what the ATF decides to do next. They stated in their initial pleadings, when they asked the Fifth Circuit for a stay, that in the event that they were denied, they would seek emergency relief from the Supreme Court. The ATF's decision to move forward with asking the Supreme Court for emergency relief would introduce another level of complexity to an already complicated situation. The Texas Suppressor Freedom Lawsuit. We will delve into the Texas Suppressor Freedom Lawsuit, specifically the PAX case, which aims to repeal the NFA and Arms Export Control Act regulations concerning suppressors. In July, the Federal District Court issued an order granting the AECA's motion for summary judgment, leading to the dismissal of the case due to a lack of standing. The federal court judge's decision to dismiss the case on the grounds of standing may seem like a cop-out, a common occurrence in such situations. The lower court concluded that none of the individual plaintiffs had suffered an injury qualifying them for standing, prompting the dismissal. The Texas Suppressor Freedom case has now been appealed to the Fifth Circuit Court of Appeals. On January 2nd, the ATF is set to present its arguments, urging the appellate court to overturn the lower court's ruling. Briefs have already been submitted to the Fifth Circuit, outlining the reasons for reversing the lower court's decision. Despite the ATF's warning letter emphasizing its intent to enforce NFA and GCA regulations against Texas-made suppressors, the case proceeded to summary judgment. The district court judge ruled in favor of the ATF, citing the lack of standing as a critical factor. According to the concept of standing, individuals or organizations cannot file lawsuits solely based on disagreement with government actions or statutes. Federal courts can only adjudicate real conflicts, and standing necessitates three prerequisites: a genuine, non-hypothetical injury, a traceable causal relationship between the injury and the government's actions, and the potential for redressability, ensuring that court relief can rectify the injury.
All kinds of firearms that take detachable magazines.
There's a hearing that you can't be at, your counsel can't be present, you haven't been charged with the crime.
And they're turning it into 10 days plus a number of steps that you have to take in order to clear your name.
The impulsive leaders at ATF have once again failed to apply simple logic and reason to their decision-making.
Involved with shooting at people?
I'm not sure in total, but...
And in the House in this coming week. On Monday...
We are taking action. We are getting things done, and we are trying to save lives.
Today, Vice President Harris will also deliver remarks at John Lewis High School, where she will talk about
For the Biden administration about these issues we are discussing today prior.
In this case, the lower court judge determined that the dispute centered on whether the plaintiffs had genuinely suffered an injury. Upon review, the judge concluded that they had not, hence lacking standing and leading to the case's dismissal. The appeal to the Fifth Circuit now awaits a comprehensive examination of the legal arguments and issues at stake. Legal analysis of the judge's opinion. In the judge's opinion regarding the Texas Suppressor Freedom lawsuit, specific aspects are highlighted to justify the dismissal based on a lack of standing. The judge acknowledges the government's history of prosecuting cases involving illegal possession of unregistered silencers. However, he contends that the plaintiffs failed to produce evidence demonstrating ownership of illegal silencers or engagement in prohibited conduct. The judge emphasizes that criminal law doctrines prohibit conviction based solely on thoughts, desires, or motives. Without concrete evidence of actual or likely prohibited conduct, the plaintiff's fear of prosecution is deemed speculative and insufficient for Article III standing.
Of 2022. Now, when it was originally introduced, it was the worst carry bill that I have ever seen.
What's changed is now we have an administration that is desperate to erode our Second Amendment rights.
And then there's one that Senator Feinstein just introduced, where it's an assault weapons ban.
They don't care about that fundamental liberty law-abiding citizens in this country enjoy.
The ATF before they abolish our Second Amendment rights. Alcohol, tobacco, and firearms.
The rule also allows certain legislation to qualify for the consensus calendar before the end of Congress.
And since most people weren't able to prove that special need,
now Texas has taken the case to the Fifth Circuit Court of Appeals, requesting a reversal of the lower court's ruling. In its brief to the Fifth Circuit, the state argues that the case merits oral argument due to the extraordinary constitutional issues it raises. Specifically, the questions revolve around whether Texans have the right to challenge the constitutionality of statutory requirements before seeking permission to pay the tax, and whether they have the right to defend their quasi-sovereign interest in the health and safety of their citizens. These constitutional considerations elevate the case to one of exceptional significance, justifying a closer examination by the appellate court. Texas Suppressor Freedom Case. The state of Texas presents its case to the Fifth Circuit, arguing that individual appellants, residents, and citizens of Texas plan to craft a homemade suppressor for personal, non-commercial use. The suppressor will be produced entirely within their homes, using generic materials with only minimal parts, such as springs, screws, nuts, or pins, potentially sourced from another state. The appellants intend to keep the suppressor within Texas borders, never transporting it outside the state and never transferring ownership to another individual. They contend that these factors establish a strong case for the validity of Texas suppressor laws and warrant a reversal of the lower court's decision favoring the ATF.
Retired law enforcement, judges, and people of that nature.
Makes it less likely for people to shoot things they are not aiming at.
The last case that they rendered a decision in that was tangentially related to the Second Amendment was in 2016.
And there's been quite a few amendments. Well, the last thing to happen just happened yesterday.
Do you think we're our safeguard on this one? Is there's no way that the Supreme Court will allow this, or is?
Let's see what is the most compelling thing to learn from that case. How many times was this gentleman?
Because Bruin said that that's unconstitutional, so they drafted SB 2, which was originally introduced back in December.
With the ATF's brief submission on January 2nd and subsequent oral arguments in the early part of the year. The crucial question remains, how will the Fifth Circuit Court of Appeals rule on the validity of Texas-made suppressors? Given the court's favorable history with administrative law issues, especially those involving the ATF and Second Amendment cases, the outcome holds significant importance. It's essential to note that despite the legal battle, the ATF maintains its stance that these items are regulated under the NFA. Multiple warning letters have been issued emphasizing potential prosecution for violating these regulations. While not legal advice, caution is advised against engaging in the making, buying, or selling of these items until the case is resolved. The pending appeal in the Fifth Circuit Court of Appeals remains a focal point for those following the Texas suppressor freedom case. The outcome will likely have broader implications, making it an essential case to watch for individuals in Texas and beyond. That's all for this video, folks. We'll see you next time.